Good evening, and on behalf of the Washington, D.C. Lawyer Chapter, the American Constitution Society, I would like to welcome you to tonight's event on expanding the judiciary and other responses to the right's unprecedented power grab. I would first like to thank tonight's moderator, ACS President Russ Feingold, and the panelists for agreeing to participate in tonight's event. This is an incredibly important topic, and I know we are all incredibly excited to hear the discussion. I would also like to thank our co-sponsors for tonight, which are Take Back the Court, the Alliance for Justice, the at-large chapter of ACS, and the ACS lawyer chapters from the Bay Area, Connecticut, Los Angeles, California, Madison, Wisconsin, New York, Oregon, and San Diego. Before I turn it over to President Feingold to introduce tonight's panelists, I would also like to let you know about an upcoming event. This Friday, the DC chapter is co-sponsoring an event put together by the New York lawyer chapter called A Basic Income for Families, the Prospects for an American Child Allowance. Please join us. I'm sure it'll be an excellent event. With that, I would like to turn it over to President Feingold to introduce the panelists and start tonight's event. Thank you very much, Mr. President.
Thank you very much, Austin, and the DC lawyer chapter, which is just wonderfully active and involved, as well as the other chapters that have co-sponsored this. Thanks to the speakers, our co-sponsors, and of course the attendees for joining us for today's discussion on expanding the judiciary and other responses to the right's unprecedented power grab. We're here tonight to discuss the vital issue of court reform. Of course, this was emphasized again by the Justice Amy Coney Barrett ascension to the Supreme Court, just as it was so painfully illustrated by the theft of the seat that should have been Merrick Garland's. The Supreme Court is out of step with the American people, and so is the federal judiciary as a whole. Indeed, there's been a ruthless willingness to destroy the norms and traditions of the judicial appointment process in the Senate that, of course, I and Nan know so well. This issue is urgent. Every issue we care about, whether it's climate change or criminal justice reform, workers' rights, civil rights, voting rights, will run through the courts. So I'm especially thrilled to be able to moderate this discussion at this crucial time as we shape the conversation on how to reform the judiciary. American Constitution Society intends to constantly lift up this subject so it's not swept under the rug. And we particularly thank the DC chapter again for their leadership on it. Look, we just have to be direct about what's happened with the judiciary. The Trump and judicial nominations, the lack of diversity, 76% men, 84% white, 65% white men, and the overall diversity statistics after the Trump nominees, 67% male, 74% white. And actually, it's not just the lack of diversity that gives me and many other people concerns about the new judges. 10 of the Trump nominees were rated not qualified by the ABA, many of whom were confirmed by the Senate. Under President Obama, 0 of the nominees were rated not qualified by the ABA. Many of these new judges also had a history of racist and homophobic remarks, including some who have been associated with known hate groups. During the confirmation hearings, multiple Trump nominees refused to even state if they believed that Brown versus Board was correctly decided. So this is our situation. The country's going to have to deal with these over 230 new federal judges for a long time. And of course, they can serve for life. Fortunately, President Biden, with the current makeup of Congress, has a chance to impact these trends. And ACS is working to impact these trends. Let me say a bit about what we're doing in this regard before we go to our panelists. It's eminently clear that we need to diversify the bench in all respects so that these judges better reflect the communities they serve. This is where our Path to the Bench project is a grassroots effort to identify diverse progressive judges. We actually have 50 working groups in 37 states who are working within their communities to identify candidates that better reflect not only the legal community, but also the community at large. This includes ensuring racial, gender, and ethnic diversity, but also, very importantly, diversity of practice, with a focus on identifying judicial candidates who are public defenders, who have represented labor unions, who have represented criminal defendants, who have been on the plaintiff side, in cases. We were recently featured in the New York Times and the Washington Post and the Nation for our work in being able to turn over 400 names to the Biden transition team within just a couple of hours that the new president was declared the winner. A large portion of these candidates were women and people of color. Over half are government, legal aid, public defender, plaintiff side, or civil rights lawyers. Only 11% are from big law firms or from corporate counsel positions. But we know, and these panelists know, that nominations are not enough. The federal judiciary needs fundamental reform. In addition to discussions about increasing diversity in the lower federal courts and adding seats to account for population growth, there are a lot of interesting and creative proposals that have put forward to about the Supreme Court itself. Many of our experts and scholars will elaborate on this, but just to quickly review, some of these proposals include expanding the Supreme Court, term limits for members of the Supreme Court, jurisdiction stripping, as would be permitted under the Constitution. Specific proposals that have been advanced by scholars include by Ganesh Sitaraman and Dan Epps, a Supreme Court lottery in which the court would sit in panels selected at random from a large pool of potential justices who would also serve as judges on the U.S. Court of Appeals. And that same pair of scholars proposed a balance bench approach in which the Supreme Court would be composed of an equal number of Democratic and Republican selected justices, plus additional justices who would be drawn from the circuit courts on whom the partisan justices would have to agree unanimously. Now, I want to be candid about this because I've gone through an evolution on this, so I imagine Nan and others have too. When I was confronting these issues, both as a young man and as a senator, I thought all this stuff sounded terrible. I thought this was the right wing's response to the Warren Court and trying to stop the progress of progressive law. But, frankly, having witnessed what has happened in recent years, it's opened my mind, and I certainly see the activism and enthusiasm of ACS students on this subject as well. The anecdote I like to tell is that when I was lucky enough to receive an award at Hyde Park from the Roosevelt Library a few years ago, I was given a tour of the beautiful grounds and hearing the history of Eleanor and Franklin Roosevelt. And I asked a question about the court packing plan. And my guide, Katrina Vanden Heuvel, said to me, "Senator, here we refer to that as the court reform plan." So I was duly chastised and never thought I'd get to the point where I'd be moderating a program that would be all about the fact that the right has stolen the courts and that something has to be done about it. Tonight's speakers will discuss their own views on the prospects of court reform, which will be just the first of many conversations to come. And I'll just mention the speakers and then go and ask each of them a question. First will be Nan Aron, the founder and president of the Alliance for Justice. I've known and worked with Nan for decades. No one is more dedicated to doing something about changing the courts than Nan Aron. And I saw her working that every day in the Congress, and I congratulate her on her announcement that she will be retiring from her current position, but that she has devoted a huge amount of her life to that cause for the Alliance for Justice. Aron Belkin, the director of Take Back the Court in the Palm Center. Aziz Huq, professor of law at the University of Chicago Law School, and also we're very happy, excellent ACS board of director member and a member of our board of academic advisors. And also Neil Siegel, a professor of law and political science, an ACS faculty advisor, Duke University School of Law, and a member also of our board of directors and our board of academic advisors. Absolutely right, Austin. This is a terrific group. So let me kick it off with Nan. At this point, the Biden administration is less than a month old, but we've already seen a Trump-appointed district court judge put a hold on an executive order issued by President Biden that would have halted deportations for 100 days. Could you just say a bit about what's at stake in the discussions about potential judicial reforms? And are progressive policy goals achievable and sustainable without judicial reform?
Well, Russ, thank you for including me on the panel. It's a treat to be here with the other speakers. And I really salute ACS for the wonderful pipeline that you all have put together that was ready on day one for a new administration. We have, working with 35 progressive groups, also put together lots of names, and we look forward to working with ACS in making sure that we're going to have some significant wins over the next few months and years. I should just add that while I'm stepping down this summer, I certainly hope that we'll have some wonderful new judges on the bench before I leave, as well as perhaps a new Supreme Court justice. No one knows for sure whether Justice Barrett will be stepping down, but if he were to, he would possibly do it in June at the end of a term. And we're looking forward to some amazing candidates, Black women lawyers who could step in his shoes and be really make important contributions on the court. So where do we find ourselves now? We've got 226 Trump judges, 3 on the Supreme Court, over 50 on the courts of appeal. And all of you know on this Zoom program that because the Supreme Court hears fewer and fewer cases each year, it's really those Court of Appeals judges who have enormous power and often render the law of the land in cases that affect healthcare, voting rights, abortion, civil rights, and then the rest of the seats are district courts. What do we know about these Trump judges? Many of them were unqualified, deemed unfit to be federal judges by the American Bar Association. We've seen just from the time that many of them have issued rulings from the court, they've taken away health care, eroded the rights for workers, environment, consumers, degraded civil rights, women's rights, and rights for LGBTQ Americans. They've had an enormous effect and will, and I would say most importantly, they are there every day, every minute of the day, positioned to frustrate President Biden's agenda across the board. So it is absolutely incumbent for the new administration to begin nominating judges as soon as possible, for the Senate to confirm them quickly, and to begin to repair the damage that has been and will be caused by these Trump appointees on our federal bench at all levels.
In your experience, do you believe that we can avoid most of this damage simply by filling as many seats as we can, or do we need judicial reform?
I think that's a beginning. And I think it's important for the next 6 months, while this commission, which I know Aron and others will talk a lot about, considers a number of recommendations for reform. I think at the moment, Russ, our work is to lean on this administration to send as many names for vacant seats. And the beautiful thing at the moment is that there are numbers and numbers of judges who have already announced they're taking senior status, they're retiring, or take senior status, which will give this new administration great opportunity. So I think for the time being, filling vacancies is critically important, but I am also a very fierce advocate for expanding the number of justices on the Supreme Court.
Well, let me take that question with regard to expanding justice to somebody else who might just be for it, Aron Belkin. Aron, could you talk about court expansion? A lot of our students have commented on, and our advocates have commented on the value of it, including their belief, and probably the correct belief, that this is possibly one of the least constitutionally suspect, if suspect at all, solutions to the problem. Could you talk about should the number of justices on the Supreme Court be increased?
Thank you so much, and would like to echo Nan Aron's gratitude to you, Senator Feingold, and to the ACS team for including me in this important discussion and for your role in pushing conversations about judicial reform forward. So thank you so much. To my mind, court expansion and judicial reform more broadly are not really about the courts, but they're about saving democracy. And they're about enabling, as Nan Aron said, enabling Congress and the administration to tackle the planetary crises we face, like climate change. And our working assumption at Take Back the Court is that even if the administration and Congress are successful at restoring democracy by, for example, passing H.R. 1, it's highly likely that lower court Trump judges would curtail, enjoin, strike down key provisions in H.R. 1, and that the Supreme Court would also do the same. Our analysis, and I realize this can be a bit controversial in some places, is that and acknowledging, of course, the critical exceptions like Obergefell and Grutter-Bollinger that when the court votes to advance rights and democracy, that even the Kennedy court was a very, very conservative and dangerous court, and that now, for all intents and purposes, the justices are acting cynically as politicians in robes in almost all instances when they think they can get away with it. And I think most primarily about a study that Senator Sheldon Whitehouse did a few years ago, where he looked at every single split decision civil case under Justice Roberts since 2005. It was 73 cases at that point. Every single split decision civil case under Justice Roberts in which GOP donors had an interest. And he found that the conservative majority voted in the direction favored by GOP donors 73 times, 100% of the time. But perhaps even more interesting is that in about half of the cases, the justices circumvented or sidestepped or undermined conservative judicial doctrine, like textualism or stare decisis, in order to get to a place that would be supported by GOP donors. So yes, we will expect a few moderating, face-saving decisions from this court, but our analysis is that democracy is hanging by a thread. There is one chance to restore democracy because it's going to become ever more impossible for Democrats to win the Senate moving forward. At most, we have a 2-year clock here, although our Senate majority, we're one heartbeat away from not having a Senate majority, and that there is really no time on the clock to fix the courts if we want to have a fighting chance to restore democracy in a durable way, and also to allow the administration and Congress to address climate and other emergencies we face.
Does your organization support a particular proposal with regard to expanding the court?
Yeah, I mean, we believe that simplicity is important, and our point is that appoint the number of justices that it will take to rebalance the court and to undo the norm breaking and the theft, which means 4 justices. Simple, clean, consistent with the 6 times in American history when the court's size has changed, and that's it.
Very good. All right, well, let me turn to Professor Siegel and ask him whether there are other reforms to the Supreme Court that could or should be undertaken to address concerns about the makeup of the Supreme Court. Are these alternatives to increasing the number of justices, or are these reforms needed in addition to increasing the number of justices? You're on mute.
Yeah, I mean, I think first, thank you, Russ, and it's good to be with so many friends. I think the issue of court packing is actually quite a difficult one. When we think about FDR's legacy, I don't think the court packing episode is one in which people look back fondly on what he tried to do and failed to do, right? Notwithstanding your experience when you were visiting. He was remarkably popular. There were Democratic majorities in both houses of Congress, the likes of which the Democrats or the Republicans today will never approach, right? I think any time soon. And yet the plan ended up failing, and it hurt his domestic political agenda. And so the first thing I would say is, if you're going to do it, you really ought to be confident that it's going to succeed. Because if it doesn't succeed, you're not going to change the court, and you are likely going to lose more elections, both in 2 years and in 4. And as I look at the politics right now, it seems to me to be premature. I don't see 50 votes in the Senate. I don't see the president supporting it. I don't see the American people accepting it. I think there's a reason why it was the Trump campaign that talked a lot about court packing, and the Biden campaign was running away from it. You then get into issues we could discuss if there's a desire about, if there's concerns about norm breaking, is this tit for tat or is this conflict escalation? We haven't touched the size of the court for more than 150 years, notwithstanding very serious controversies and disagreements with the decisions that the court had rendered, including, among other decisions, Brown against Board of Education. And then you get into questions about the consequences, putting aside whether there's still a norm against it. It seems to me progressives have a stake in the federal courts and the Supreme Court being perceived as legitimate. And if we think they couldn't be more politicized, then we lack imagination or knowledge of comparative politics. There's also concerns about what's going on in the minds of the justices themselves. The Supreme Court and the federal courts, in my view, performed well in the aftermath of the election. And it seems to me that's an argument against court packing, not for it. Where would we be if we had utterly politicized federal courts that was prepared to simply validate the former president's repeated lies about what had actually happened in the election? So, I'm not going to say no, never, no matter what. I think there are things the Supreme Court could do that would put court packing on the table. We can talk about that. But a different kind of reform that I would be, I think would be I'd be less concerned about the consequences of and the sort of the normative implications of is term limits, is 18-year non-renewable terms for the justices, which I think is entirely justifiable as a matter of good governance. It simply doesn't make sense to put people on the Supreme Court with the power the modern court possesses when they're in their 40s and have them stay there until they're 80 or 90, right? I mean, it's sort of like, the 80 is the new 70 on the Supreme Court. With that degree of independence and that lack of accountability, I think it would also have the virtues of taking some of the partisan warfare out of the confirmation hearings, because everyone would know it's going to happen every 2 years. Now, there are still risks in terms of destabilizing the law and having it change every 2 years. When you're talking about fundamental changes, right, we can't know what the consequences entirely will be. So I think that has to be studied carefully. I think the biggest downside, and it's a big one, is I'm not persuaded how it can be done without amending the Constitution. And I don't see a constitutional amendment succeeding, given how few houses of 13 state legislatures can defeat an amendment. But I think that's one that I would, on good government grounds, be prepared to support if it were possible.
Yeah, this one intrigues me as well, because you think about the founders, they couldn't possibly have imagined this kind of life expectancy as a general thing, and that people would be appointed so young. I mean, some of the critics, when we point out that this is a rather absurd situation, say, well, what about Oliver Wendell Holmes? He was there till he was 90. But, obviously, there has been such a substantial change, you have to question whether the founders really would have intended this sort of situation. So let me turn to Professor Huck. We've discussed several potential reforms, but is there any precedent to the kind of significant reform of the judiciary that's being discussed today? And if you could say a bit, Professor Siegel was getting us in this direction, though. Are there any constitutional hurdles that progressives are going to have to overcome to implement these kind of reforms?
Well, I don't know, Russ, how much time do you have? We can do a whole
That
courts
could
class
be
on
an
that,
hour and a
right?
half.
It's good. I usually spend a quarter at Chicago doing that. Well, thanks first of all to Russ and to Austin for setting up this event, and thanks for all who are listening in. I think a way of thinking about the question Russ posed is by going back to the constitutional design and thinking about the opportunities and the incentives that it created for political actors, because I think it puts our predicament in a distinctive light, and it explains what's happened over the last few decades in terms that flow from the Constitution. So the key fact about the federal judiciary, as it's described in Article 3 of the Constitution, is that there's not much of it. There's a Supreme Court, which, if you squint hard at the text, can be reduced to a single justice. And there are no lower federal courts. There are no lower federal courts. So when the Republic comes into being, there is little by way of a federal judiciary. And the creation and development of a federal judiciary, the creation and development of the set of institutions we're talking about today, has always been at the beck and call of Congress. It was Congress in 1789 with Oliver Ellsworth at the pen, which designed an initial lower federal court system, one that didn't have our familiar courts of appeal. It's Congress that decided in 1789 not to allow federal courts to hear cases just because they had a question of federal law. It was Congress that decided that year to limit the Supreme Court's jurisdiction to questions in which a federal right had been denied. And it was Congress a decade and change later that in the infamous so-called Midnight Judges Act expanded the courts, added federal jurisdiction, stripped away one justice from the Supreme Court, and prevented the new incoming president, Thomas Jefferson, from adding a new justice for a whole year. Right? The Jeffersonians repealed that, but the basic tempo and rhythm of the Congress creating jurisdiction and deciding the kinds of cases that both the lower courts and the Supreme Court could hear was a constant from the beginning of the Republic, at least until the 1920s. The stability of the courts and the relative inflexibility of their jurisdiction is a modern phenomenon. It is not a feature of our Republic from the get-go. So our courts have always been the work of legislative design. They've always been the work of political actors in terms of what they can hear, in terms of what kind of an institution they are. And who sits on the court has obviously always been a question of politics, a question of who can get through the process of nomination and confirmation. And to be sure, the nature of that politics has changed over time as the country has become either more or less polarized. But ours is not the first, and it won't be, I hope, the last time in which polarization is higher rather than lower. I hope we go through cycles again. I hope the country lives that long. So the recent period of aggressive Republican appointment to the court as part of a partisan political strategy of advancing certain policy goals that cannot be advanced through legislation because they're unpopular, or they would be vetoed, or they would hit roadblocks in one or other committee, is nothing new. And the idea that once Democrats come into power, that they would employ precisely the same tools to alter the institutional contours of the court is also nothing new. It is the way that the Constitution is supposed to work. It is a product of the incentives for political actors and the opportunities for those actors that the Constitution sets forth. Now, Russ is absolutely right. There are constitutional constraints which principally attach to the way that the Supreme Court can be altered, and that principally or secondarily attach to the way in which an individual judge can be treated, for example, moved from one place to another within the judicial hierarchy. But the scope of congressional control over what it is that the courts in fact do in terms of jurisdiction is exceedingly broad. Yes, there have been academic arguments since the 1950s about why congressional control should be limited, but those academic arguments have rarely cashed out as actual constraints upon legislative behavior. So there's a very wide field. There are constitutional constraints, but it's important to recognize that pursuant to our constitutional design, the structure and the functioning of the federal courts are a matter for the political branches and have always been that.
Well, I think you did a great job of condensing that month into a very good answer. Thank you. Let me sort of ask all of you to just try to respond to this as you wish. This is obviously not just a problem with the Supreme Court, as Nan pointed out. This is a problem with the entire judiciary. So let's talk a little bit about what reforms are needed at the district and circuit court justice level. Nan, you're nodding. You want to kick that off?
Sure. Well, not only is there the issue of Supreme Court expansion, which is what I refer to as democratization. But the Administrative Office of the U.S. Courts put forth a proposal, I think in 2019, calling on Congress to add new seats to courts of appeal. I think it was something like 3 or 5 Court of Appeals and 65 district court seats. And I certainly think it's high time for Democrats to take that up in both houses and pass legislation. I do remember over time, Russ, you may remember this too, that we've been through some of these fights together, that Republican presidents, I think Reagan and I think I think George H.W. Bush, both pushed hard for expansion of lower court seats. Democratic presidents, I don't think have done it. And I think this time around, it's critically important for Biden to take that up, and for Congress to take that up as well. We just got a group of 70 organizations to come on board calling for expansion of lower courts, and we certainly hope that that happens over the next year or so.
Thank you. Yeah, please.
Oh, I'm sorry. I was just going to back and fill a little bit what Nan said, since this is an issue that I've been interested in. So it's worth knowing that between 1960 and 1990, Congress passed 6 comprehensive judgeship bills. And the failure to enact a lower court reform measure since 1990 means that we are currently living in the longest period since the creation of the modern federal courts in the late 19th century, in which those courts have remained unchanged. The issue of alteration of lower federal courts has been in front of both the 115th and the 116th Congresses, and has attracted bipartisan support. Indeed, that there was a bill that was proposed on the Republican side in 2018 that would have added 60 seats to the lower federal courts. If you take the failure to expand the lower federal courts since 1990, and you measure the change in the volume of litigation that's happened, and you compare the static size of the lower federal courts to the change in the absolute level of US population, you come out with larger, potentially significantly larger estimates of what an appropriate per capita expansion of the federal courts would look like today.
Anybody else want to comment on this one?
Yeah.
Sure.
So I don't disagree with any of those points, but I come at the question from a slightly different angle, which is, as a political science professor, I can say democracies don't work when courts are stolen. And Mitch McConnell effectively prevented President Obama from filling lower court vacancies in his first years in office. And then Harry Reid solved that problem by getting rid of the lower court filibuster. And then when the Republicans came back, they again took the Senate in 2015 and prevented Obama from filling lower court vacancies for his final 2 years in office. If Senator Reid had not made that move, I believe Trump would have inherited about 200 lower court vacancies instead of the 100 he inherited. Look, Mitch McConnell and the Federalist Society and the party, they work together to steal courts, to play ruthless judicial politics, because that's what they need to do to win elections. Take Back the Court did an analysis of about 300 election-related decisions running up to the 2020 election. And we found that Republican judges and justices voted to make voting harder about 80% of the time. Whereas democratically appointed judges and justices voted 37% of the time to make ballot access harder. And so what I would say now is that the lower courts need to be expanded, yes, for workflow reasons, but also commensurate to the number of lower court seats that were taken from President Obama. You can't allow norm breaking to go uncommented on in a democracy. One procedural point, and then I'll stop in case Neil wants to weigh in on this, is that we're about to roll out a plan that makes the case that lower court expansion bill could go through budget reconciliation and could pass the merely incidental test of the Byrd rule. And so we're hoping that Democrats stop at nothing to undo the theft of lower federal courts.
Neil, you want to weigh in on this one?
Yeah, I do. Thank you. Yeah, I think there are a number of strong arguments in favor of expansion of the lower federal courts, both the federal courts of appeals and the district courts, and a number of them have been touched on. I do think there are judicial efficiency workload reasons. I also think there are existing vacancies that really ought to be filled without delay and frankly without much consultation from the Republicans. And I think judicial legitimacy cuts both ways, right? I mean, when I say progressives have a lot at stake in the courts being legitimate, well, legitimacy exists in the minds of an audience. And to me, what it means for the federal courts to be legitimate is that they look like the United States of America. They don't look like the Republican Party. And I think that's a serious problem of legitimacy when you have the kinds of appointments that we've had over the past 4 years. And so I think diversity is another important rationale here. I understand as well, right, concerns about nominees who are adjudged unqualified and in some cases of questionable moral character. I'm also concerned about certain nominations that the judges see about as norm responsive as the people the president ultimately put around him when his earlier executive appointees were prepared to push back against what he wanted to do. And I think that matters as well. Now, the one word of caution I would add is that I would avoid something like what Professor Stephen Calabresi of Northwestern of the Federal Society proposed, which was basically a proposal to flood the lower federal courts with, I can't remember exactly how many, but many Republican nominees as quickly as possible, right before control over the White House and the Congress changed hands. And that was, I think, widely ridiculed as just, over the top, pure partisanship. And my understanding is he eventually withdrew the paper in which he made the proposal. I don't think you need to go nearly that far to make a very significant process in terms of changing the composition of the lower federal courts. And that is, after all, where the vast majority of the business of the federal courts takes place. And I think it's one thing for the Supreme Court to do what I fear it's going to do and be pushing against, right, an open door in terms of the lower federal courts. It's another thing for the lower federal courts to be pushing back very significantly, and it being even more apparent that the Supreme Court is not simply, right, applying the law, that it's actually rendering decisions that the vast majority of the federal judiciary is not prepared to countenance. And so again, I think there are some very utterly justifiable reasons to focus on changing the composition of the lower federal courts.
Sorry, just briefly, the reason Calabrese was widely criticized, including by Republicans, is because the Republicans were able to steal lower courts and the Supreme Court without expanding the lower courts and flooding the system. Again, like, we have to take that history into account when we consider what's done now.
Well, let's talk some more about that history for all of you weighing in a little bit on this, to make sure the people who are watching this and participating in this know how we got here. One of the things I've noticed with the whole Trump phenomenon is people tend to think everything started in January of 2017. It was a lot of things, and in a lot of ways, Trump was a symptom of various strategies that were adopted in the political world. Well, the same thing goes for what culminated under Trump with regard to judges. You can actually trace a line backwards from Mitch McConnell's rushing Justice Barrett's nomination through right before the 2020 election, to McConnell holding up Judge Merrick Garland's nomination at the end of President Obama's term. But this didn't start in 2016. So talk a little bit about what conservatives have been doing to the judiciary for the last several decades. And to be honest, are there any lessons that progressives should take from this? How does history help us formulate a plan going forward?
I can start.
Yeah.
Well, I would say, as Aziz says, it's a messy process. The Constitution gives the Senate and President co-equal powers, and therefore it's always, nominations are frequently subject to debate. And but one party has seized the day on judicial nominations, and that began long before Donald Trump. It began in 1954 with Brown versus Board of Education, and people in this country for the first time put signs on their bumper stickers on their car, impeach Earl Warren. There were groups of people in the South that turned against the court, and that group only expanded with Roe versus Wade. And abortion rights really became the rallying cry, as it is today still. And what helped those individuals, the right wing of the Republican Party, was the Federalist Society, which gained ground and began to raise a lot of corporate money. Look at the law firms that support, it's deplorable, but support the Federalist Society today. And here you had both large corporations working together with the right-wing base of the Republican Party, who felt passionately about the courts and whose Republican senators acted in concert with. Ronald Reagan came into his second term unsuccessful in getting Congress to go along with his agenda, and said, you know what, forget Congress. I'm going to appoint judges who I know will implement my agenda. And ever since the early 1980s, modern day court packing, you've got a Republican Party backed by a very energized constituency, pushing for the kind of judges that Donald Trump put on the federal court. And the good news about that is that progressives largely because of the Trump judges, are galvanized around the courts, the judiciary, and judicial nominations in a way that we've never seen. And interestingly, not just about the Supreme Court, but lower court judges as well. So I do think that passion now is being felt on the left as much on the right. But you certainly have had a Republican Party that has been focused, prioritized the judiciary for decades. We got to catch up.
Can I just build on what Nan said briefly? I think there are two strands to the Republican Party strategy with respect to the judiciary, at least since the early 1970s, that are woven through what Nan has said, and that much of the debate on the progressive side is about which of those two strands is important. The first strand is one involves the articulation of an allegedly coherent philosophy of interpretation, which is labeled originalism. The second is the ability to, in a way that even Facebook might envy, micro-target the delivery of particular public policy goods to elements, often quite heterogeneous, very, very different elements of the Republican coalition. In my view, the existence of a supervening judicial philosophy is relatively unimportant, right? The fact that people call themselves originalists doesn't have much determining power about the results that they reach, and it doesn't actually distinguish them from liberal judges or judges who are appointed by Democratic presidents in methodological terms as cleanly as I think the Federalist Society would like to suggest. Rather, I think that the key to the energy on the Republican side has been the ability to offer the judiciary as an instrument for the achievement of particularly precisely targeted goods, right? So this is, on the one hand, the reform of class actions, the reform of consumer litigation for a corporate audience, right? The audience that justices like Lewis Powell in his former role as counsel to the Chamber of Commerce reflected. It's at one point in time and on an ongoing basis, the ability to deliver increasing narrowing and then perhaps one day repudiation of Roe v. Wade. And today it's the ability to deliver a particular form of religious liberty entitlement that the most important effect of which is the right to act on the basis of religious conscience in a way that inflicts harms on third parties. So one thing the left or the Democratic Party has to think about is this strategy of targeted public policy good delivery through the judiciary on the right, how it worked, why it hasn't happened on the left, and whether it could happen at some point in the future.
Other comments on this?
I think if I could generalize what I hear Aziz saying, I mean, I think what I most hope the left learns from the right, because I think Republican views over the last several decades about the courts, right, provides opportunities for learning and not just for villainizing. Although I should say, I was in the Senate working on Gorsuch and Kavanaugh and Barrett, and so I saw it up close. And a lot of it is worse up close, right, than what was reported in the media. So, I have been highly critical of the behavior of Senate Republicans with respect to the courts, and so I understand and to a large extent empathize with the objections. But there's also there's also things to learn and responsibility to take. Republicans have cared about the courts in general a whole lot more than Democrats. Conservatives have cared a whole lot more than liberals. Think about how much of a priority it was in the Clinton administration and the Obama administration. Think about how much the Biden administration is trying to do differently now. To put it even more concretely, how often did Hillary Clinton utter the words Merrick Garland in running for president in 2016? How much outrage was there on the political left about it? If there was nearly as much concern on the left as there was on the evangelical right about the Supreme Court, we would not be, look, I can't prove this, but I strongly suspect, given that Trump won by something like 80,000 votes, a football stadium in 3 states, I strongly suspect we would not be talking about court packing. We would be talking about a US Supreme Court transformed, given how utterly consequential this one election was in ways I don't think we could have imagined. I thought maybe 2 seats, but not 3. And so, right, it's easy to say they should really care more. I think Aziz is pointing to one way we can think about how to get people to care more. But I really hope folks on the left, particularly young people on the left, don't just give up on the courts as conservative institutions that either impede progress or make progress way too slowly. Because if we continue not to care nearly as much, I feel we're going to continue to get the results that we've gotten.
I would, go on, sorry.
I was just going to say, I'm intrigued by this question of whether there's staying power for this change on the left, which Nan correctly reports, documented this week by a Pew poll. Something really kind of amazing happened, of course, in this recent process that didn't happen with Merrick Garland. We all know Merrick Garland's one of the most wonderful people in the world, but people didn't know who the heck he was. But they did know who Justice Ginsburg was. And to see her die in that way, to have her dying wish not fulfilled, to see the rush to judgment, I think it had an impact. I can't prove it, but I think it had a tremendous impact on people realizing how outrageous these tactics of theft are. Now, does that have staying power? I mean, a lot of younger people really could consider her a hero. And I just don't know the answer. But it could be something that is transformational going forward. Sorry, Aron, I cut you off. You were going to comment on this one.
Oh, no, that's okay. I mean, just on that question of staying power, Democrats already favored court expansion by a majority before Justice Ginsburg died, and most polls show that, and independents by a plurality. And that's really before thought leaders have made the strong case for court expansion to the public. So yes, I believe that support is here and it's going to continue to grow as the court continues to take aim at everyday Americans on behalf of the Republican Party. I just want to say, circling back to one thing from the previous round of the conversation about what progressives and Democrats might learn from the right. And I can't emphasize enough the importance of cynicism. And I'm remembering the moment when ostensible moderates like Senator Burr and the late Senator McCain said that even if Hillary Clinton won the 2016 election, they would hold the Supreme Court frozen at 8 so that they could take it next time the Republicans took the White House. I'm mindful of the way the Republicans tried to shrink the size of the DC circuit, which is kind of reverse court packing. I agree with what Professor Hook says about the deliverance of micro-targeted policies. But I really think that there's a kind of more straightforward way to understand what's going on, not just in terms of retrograde economic policies, not just in terms of policies that uphold patriarchy and white supremacy, but it's about Shelby County, and it's about hyperpartisan gerrymandering, and it's about stealing elections and destroying campaign finance limitations. And unless and until progressives and the Democratic Party realize why the Republicans have been so ruthless with the courts, and that there is nothing, that normative violations like that cannot be left unresponded to if we want to save democracy, then we're just fighting an uphill battle.
Aron, I'm going to ask you to kick off the next one too, and this one's more forward-looking. There are people, and it's been alluded to, I think, in some of the things Neil said, who say that Democrats should be careful with their reforms because they run the risk of inciting a backlash from Republicans when they regain power. For example, with expanding the court, if the Democrats increase the number of justices to give themselves a majority, as you've suggested, Aron, the Republicans could do the same the next time they're in power. How do you assess the risk of creating a cyclical tit for tat? Why is it worth it to proceed with judicial reform despite those potential risks? So start with Aron on this one.
Yeah. Professor Thomas Keck at Syracuse makes a brilliant distinction between constitutional hardball that's designed to sabotage democracy, like Shelby County, and constitutional hardball that's designed to restore democracy, like expanding the court. I would point to three things in response to that concern about retaliation. And I would mention at the top, the arguments against court expansion look good on paper, but when you scrutinize them, from my perspective, they fall apart quickly. So let's think about Republican retaliation. 3 points. 1, if your wallet is stolen, you don't forego efforts to recover it because it might be stolen again. The court has already been stolen. And if we unsteal it or rebalance it and then it's stolen again, we're no worse off than we would be than we are today. And especially at a time when there's no time left on the climate change clock, I would argue that a zigzag where they steal the courts, we rebalance, they steal, we rebalance, that is better than unilateral surrender for a generation. That's 1. 2, even if Democrats do nothing with respect to judicial reform, not even a code of conduct, the Republicans will pack the court next time they need to do so if they have the chance and have to do that to control it. How do we know that? Because they've been packing state Supreme Courts for years and have gotten away with it in Georgia and Arizona. And as Professor Siegel mentioned, the modern idea of court packing was from the former co-founder of the Federalist Society. The party has clearly shown that it does not care about norms. We have a member of Congress now who has called for Nancy Pelosi's assassination, but the party won't sanction her. The party is not committed to democracy, is not committed to norms, and it will pack the court if it needs to do so, regardless of what Democrats do. Third and finally, as I mentioned at the outset, court expansion is not about the courts. It's about saving democracy. The safest way to depoliticize the courts, the safest way to prevent Republican retaliation, the safest way to prevent future normative violations and to preserve the court's legitimacy is not just about court expansion, it's about de-radicalizing the Republican Party. And the way you do that is you force the Republicans to play on a level field. You force them to have to appeal to a majority of the public. You unrig the system by passing an aggressive version of H.R. 1. And if you do that, then the Republican Party will be incentivized to appeal to the median voter instead of just juicing its base with radical policies that include stealing courts. The point is, if you kill the filibuster, pass an aggressive H.R. 1, and then protect that H.R. 1 by expanding the court, that's the way to de-radicalize the Republican Party. And it's a de-radicalized Republican Party that will decline to expand the court moving forward.
Aron, let me add a question to you that I'll add for everybody that relates to this. It comes from one of our participants. What would happen if the response was tailored to the two thefts, the Scalia and Ginsburg thefts? In other words, 2 seats, in an attempt to restore norms and saying, look, basically reparations. How does that hit you? And it's an interesting question, and then I'll ask the others to respond.
The case for court expansion involves 3 things coming together. I would argue for the first time in American history, we've had elements of all 3 before, but never all 3 together. A stolen court, a court that itself is sabotaging democracy, like in Shelby County, and a court that's highly unlikely to allow Congress and the president to address planetary emergencies like climate. We need a court immediately that will allow the president to restore and Congress to restore democracy with H.R. 1 and address climate change and gun violence and other emergencies, and adding 2 seats to the court will not address that problem.
Others on the potential backlash question.
I guess I would say adding 2 would be a good start. Not complete, but a very good start. But I would add a couple factors to Aron's excellent analysis. One is for the Republicans to pack the courts, democratize the courts, they would have to win the White House, the Senate, and the House. It's going to be difficult. They've lost all popular votes in national elections since the year 2000, except one time. They don't have a particularly good track record. And two, I would argue, I guess this is supporting Aron's point, is that this Supreme Court is about, yes, challenging democracy, but I would go farther and say it's about keeping the Republicans in power. Partisan gerrymandering. Look at the Janus case, which reduced the power of labor unions around the country. That was about reducing the power of the Democratic Party. Shelby County voting rights. All of this is designed to keep that party in power. And I would say, I think we learned a lesson from the last election, and that is, I think Americans want our government to function and function effectively. I think they want government to work well, protect the health and welfare of American people. I don't think that's a direction that this court is going in. We've got at least two justices on the Supreme Court, Kavanaugh, Amy Coney Barrett, both of whom had records in opposition to healthcare, the Affordable Care Act, and would have taken healthcare away from millions of Americans. Neil Gorsuch may have been silent on healthcare, but by the same time, he's very critical of the so-called administrative state, which essentially means he'd like to reduce the regulatory activities of agencies in this country. We are in a very dangerous point in our country, and we've got a court deeply entrenched by radical right justices who will not rule in a way that will protect our rights and freedoms.
Well, we really are in a fraught situation. And Nan, you and I both know that even though it would be hard for the Republicans to take over everything, it's razor thin in all three places. I mean, it could change in one election. The other thing is they're willing to, as you pointed out, you know, if the Supreme Court thing somehow falls by the wayside, they'll do other things, like what they did in Wisconsin in 2011. They gutted labor unions. That was for political reasons. And in fact, there's a heavy movement that I've been studying fairly extensively to try to call a constitutional convention. And they're either 4 or 6 states away. And one of the things that's been thrown out there is to throw changes to the judiciary into that as well. So just as a general point, but I'd like to get back to either Neil or Aziz on their sort of response to the backlash question.
Neil, do you want to go, or do you want me to?
Go for it. Happy to follow up.
I think it's useful to distinguish between two dynamics on the Republican side that have very different timeframes and that inform the backlash question that you asked, Russ. The first is the fact that for the last couple of political generations, the Republican Party has benefited electorally from shrinking the electorate and narrowing participation with respect to through the resistance to campaign finance and through barriers to voting. Right? That's a secular fact about the Republican Party that is now durable. It's been the case for at least 40 years, maybe a bit longer. Correspondingly, the Democratic Party has had an interest in expanding the electorate, leveling the playing field with respect to participation in the form of campaign finance, and expanding the range of civil society organizations, most importantly unions, that can participate in electoral politics. Right. So to my mind, it's not satisfying analytically to say that or to kind of fall back on the claim that it's just democracy, right? One has to pay attention to the fact that the party's long-term incentives cut in different directions for democratic reasons. They're driven by responsiveness to the fact of elections, which push them towards certain kinds of strategies, right? So the first point is that there's a long-term secular trend of Republicans resisting expansion of democracy along various, or expansion of democratic participation along various margins, and there's no particular reason to think that that's going away. The second point that I want to make is that in the last 3 years, we've seen something qualitatively different within the Republican Party, which is a detachment from norms of shared factual ground, an unwillingness to accept or to police even basic norms, even elementary norms of political conversation, without which the fact of democratic contestation cannot occur. And most fundamentally, an unwillingness to admit the possibility of electoral rotation. To my mind, if that shift in the Republican Party, the short-term shift that's happened in the last 3 years, locks in, then the Supreme Court becomes irrelevant, because we no longer have the structural conditions for a democracy. You need at least 2 major parties for a democracy, both of which accept the rules. And if we don't have that, we don't have the structural conditions for a democracy. It just doesn't, all of this stuff about courts just doesn't matter. And so to my mind, it's sort of odd to talk about the question of backlash or retribution without recognizing that the question becomes dramatically different if we have a Republican Party that is structured in so as to disfavor expanded participation for reasons that have been the case since the 1980s, or whether we have a Republican Party that is unwilling or unable to accept the possibility of democratic rotation, which is what we've seen in the last 3 years emerging, at least as a possibility, and is something quite new and distinctive in the modern era of American politics.
Neil, could you clean up on this one?
Yeah, sure. So, I mean, I largely share Aziz's diagnosis. I mean, when I talked about racially polarized parties, I mean, you have one party that is overwhelmingly white, predominantly Christian, right, and rural, in a country that is increasingly racially and ethnically diverse, as well as secular and urban. And I think that goes a long way towards explaining the kind of existential politics that Aziz is describing in recent years. And I think it's terribly worrisome. I think it's a lot more important than debates over courts, although I do think it does hook up to debates over courts. And so I ask myself, what are the circumstances in which courts are going to be most likely to stand up and push back, at least against the greatest threats, like we saw right in the wake of the election? And so my concern about expanding the Supreme Court or court packing, depending on your point of view, is not that the Republicans will do it back if they get the chance. I think you need unified control of the political branches, and yeah, there's no doubt that they'll do it back if we do it. And I think you know, they very well might do it even if we don't do it. You know, I think there's a lot of truth to what Aron is saying, and yet I still worry about fundamentally changing an institution based upon what has happened, right, with respect to the Supreme Court over the last 4 years. I think the idea that we would add 4 seats and it's just going to all be the same, it's going to have the same kind of public legitimacy, the same degree of compliance, the same degree of executive enforcement, no matter how loathsome the executive finds the decisions, that the justices, right, are not going to be even more politicized than they are, and there's plenty of ways in which it can be worse. I think those are the kinds of questions that worry me when I think about expanding the court. The other thing I would say is that, you know, at some points tonight, I was starting to lose the thread a little bit, because I'm hearing a lot of different arguments for expanding the court, right? It started with really bad behavior by Republicans, and we have to respond in tit for tat fashion. And I think what some call tit for tat, I worry about as conflict escalation. Right. I mean, tit for tat to me would mean not considering, as a Democratic Senate, any Republican nominee for the Supreme Court. I think court packing, in my view, is upping the ante. But nonetheless, it's is the argument bad behavior? I keep hearing about stolen seats, which we could talk more about whether that means, or is it simply that if you find what the court is doing or you fear is going to do highly ideologically objectionable and you think the stakes are very, very high, those are sufficient grounds to add seats to the court? That seems to me to be right a more encompassing justification that would justify routine changes in the composition of the court, including in response to Brown, including eventually in response to Roe or in response to Obergefell. It's not as if only one side in this deeply divided country finds certain Supreme Court decisions highly objectionable, immoral, wrong, and really something that threatens the future of our democracy.
Before we're done, I'm going to come back and ask you about the bipartisan commission that President Biden is forming on judicial reform. But let me go to a couple more questions from our participants. And Neil, you kind of were moving in one direction. There, I'd go the other. You talked about conflict escalation. What about conflict avoidance? One of the questions that we got here was, given what the court was doing in the last term with a number of those decisions, Roberts, Gorsuch, others, is this analogous, as the question asked, to the stitch in time that saved 9 in the FDR era? Is this something that will be effective or really pursued by the court to try to avoid the expansion of the court? What are your thoughts?
Are you asking me, Russ?
I'm asking you and everybody else. Start with you, Neil.
I think it's too soon to tell. I mean, the Chief Justice does worry publicly about the court's public legitimacy, and I think some of what he does, right, is some degree of moderation, as opposed to vindicating his own legal and ideological views. Although he's still a very, very conservative justice, we'll see the extent to which someone like a Justice Kavanaugh is responsive to that. We don't know. And I'll reiterate, I'm not prepared to say under no circumstances should we expand the size of the court, right? There are things they could do. If you get 5 votes for Justice Thomas's view of the Commerce Clause and the Necessary and Proper Clause, and you're talking about dismantling American government, right? The more they push in an anti-democratic signing off on voter suppression direction, right? I think the more alarming it becomes. So I think it's too soon to tell. And I hope this Judicial Commission doesn't make any permanent close the books recommendations, right? That this needs to be continually revisited. But we're going to find out. We're going to find out in the years ahead. I don't think they're going to be doing, right? I don't think they're going to be doing certain things just to fight off court reform forever, right? I think eventually we're going to see what this court is, this newly constituted court is really about and how far they're prepared to push.
Aron, how do you react to that in light of some of the things that happened in the last term?
So even conservative court experts made the case that part of the reason for the decision last term in Bostock and on gun safety and reproductive justice and DACA, the moderation of those decisions was the court's concern about court expansion. I actually draw slightly different lessons to what happened under FDR, and I know historians debate whether the court was aware that Roosevelt was going to try to expand it or not. I believe the preponderance of evidence shows it does, but I think that was a successful moment, and that we might not still have this Social Security Act if it weren't for Roosevelt's attempt to expand the court. Look, I want to say one thing about the very important points that Neil raised about legitimacy. There's certainly merit to that point, but how legitimate would the court be seen today if Democrats had gotten control of it through normal rotation? I mean, the vast majority of Republicans don't think Biden is the legitimate president. The reason that Republicans think the court is legitimate now is because it delivers hyperpartisan decisions the vast majority of time. So whether the Democrats expand the court or not is legitimacy, the court's legitimacy is going to be gone if and when Democrats retake it just by normal rotation. And so I think that's very important context to keep in mind. It's yes, of course, the courts, lower federal courts and the Supreme Court made important decisions after the election that ruled, prevented Trump from stealing the election. I would argue those were just obvious cases where it would have been too hard to get away with another Bush v. Gore. I think the more revealing data point is how they behaved before the election.
Aziz, do you think that what the court's behavior in the last term had anything to do with this possibility of judicial reform?
I incline to think that, as Neil said, there's good reason to think so, although it's very hard to prove so. I would also echo the last thing that Aron said about the how to think about the court's role in the presidential election context. The courts were asked to do two different kinds of things by the various challenges that former President Trump and his attorneys or allies brought to the courts. The first is that they were asked to recognize new and untested principles of constitutional law that would have granted large advantages to the Republican side. In particular, reading Article 1, Section 4 to vest state legislatures with exclusive authority over elections in relation to state judges and state secretaries of state. And second, they were asked to make up the specific facts of the cases that were before them. It's very hard for a judge, even one who's not terribly competent or ethical, to just make up facts about the case in front of you. It's far easier, whether you're an originalist or not, to make up a legal principle that dramatically advantages your side. And so one can think about the, if you're thinking about what happened in the latter months of 2020 as an attempted coup, where the coup unfolded over several margins in different ways, some of it violent, some of it judicial, some of it rhetorical. One of the failures of the coup maker was to pick the wrong kind of case to bring in court. I think that we won't be so lucky next time.
Dan, you want to finish up the question of the court's behavior in the last term and the relation
Sure.
potential?
I mean, I guess I look at the political reality. Nothing will happen. We have a couple senators, Manchin, West Virginia, Sinema from Arizona. They're not inclined to vote for court expansion. So those proponents of court expansion have their work cut out for them. And two, I think it does remain to be seen what this term looks like. I don't hold out much hope. I'm sure people who are tuning into this Zoom know full well the records of Gorsuch, Kavanaugh, Barrett, as well as the other justices, and know exactly what they're going to do. And obviously there are moments when the justices surprise us, as Gorsuch did in an LGBTQ case, but I think we've got some time. I do think if the justices render decisions that, and if progressives are good at making a connection between those decisions and people's lives and the issues people care about, we have a fighting chance for court expansion. But that's the work that we need to be doing when that Supreme Court starts handing down decisions that are really harmful to Americans. We haven't done it enough. Our senators haven't done it sufficiently, and that's the work that remains for us to do.
Great. We have time for a couple more questions. The second one will be about the Biden Commission, but this one is from one of our people in our audience here. The reaction to the Biden administration announcement about not waiting for the ABA recommendations. Yeah.
Well, the ABA.
So it's you.
Well, ABA was, through history, really a safety valve. I remember, and I'm sure you do, Russ, there were moments when senators wanted their golfing buddies to become judges, and the ABA said, not so fast. And presidents wanted their big political donors who really weren't accomplished in the law. And the ABA would say, not so fast. But we've seen something very disappointing over the past 4 years, and that is we saw an ABA who I believe leaned over backwards to give Trump nominees qualified ratings. And you know, the language in the ABA standard is judicial temperament. Well, most of these individuals who are now sitting on our federal bench have very little judicial temperament, no compassion whatsoever. And I was frankly really disappointed in what the ABA's done. There's also been a criticism about the ABA that they've held people of color and women to a higher standard than white nominees. And obviously there've been so few people of color nominated by Trump. But I do know, going back in time, that Black nominees, Latino nominees, and women often had a much more difficult time getting high marks from the ABA than their white counterparts. So I'm not at all upset with the ABA not being part of the pre-nominations process. They'll still have some role, but I do feel that they've got to refresh their work, their standards, and take a different approach.
Let me leave that one there because we only have 5 minutes left, and we only have time for a lightning round now on the President Biden Bipartisan Commission. Given everything that we've discussed tonight, and it's been a great conversation, what is the one recommendation that you hope the commission will make? Who will volunteer to be first?
Well, I think you know what Aron and I.
Two votes for justice's expansion, right? Belkin and Aron, correct?
I think so. I don't want to speak for you, but
I think
I'm good.
All right.
I think that's where we are.
Neil?
So I think I've already spoken to this. I think lower federal court expansion, at least consideration of term limits, and then finally, I think a statement that whenever the commission ends, right, the kinds of questions that it's tasked with considering doesn't end, because I think a lot depends upon, right, how the court behaves over the next 5 to 10 years. And so I think a commitment to revisit, right, as opposed to sort of checking a box and then being done with it.
You have 180 days. Yeah. All right, Aziz, can you finish it up?
Sure. I feel like now I know how contestants on Wait, Don't Tell Me feel at the end of the show. They're made to come up with joke right at the last minute. I feel like the question has the same force to it. What I hope the commission does for the American people is to tee up a question that, to my mind, is not satisfactorily answered. It's how can the federal courts best serve the American people? And we've talked a lot about the ways in which they don't, and they're complex. They're to do with the ways that certain progressive reforms are blocked, certain interest groups get their voices heard excessively in the federal courts. We haven't talked about how ordinary men and women who suffer from police violence at the hands of immigration officials and the like, don't have a day in court, often because of judge-created doctrines. So what I hope is that the commission really puts on the public radar the question of how can the federal courts best serve our democratic people, and not just a small slice of them, but everybody.
Thank you.
And sorry, Russ, I actually would like my 30 seconds. Is it okay to?
Sure.
I'll just say one more thing about the commission. The commission, I think, has something important to do in recommending the possibility of expansion and recognizing the depth of the problem. I just want to say I couldn't defer more to Neil and his incredible legal expertise and decades of work in the field. But Commerce Clause, administrative state, yeah, it's enough that the Republicans stole the court and destroyed the Voting Rights Act so that Black and brown people couldn't vote. Like that's enough. Like the lines have been crossed. We're already there. And I hope the Biden commission recommends that.
Well, this has been just a tremendous panel. And for me, the hour and a half went very quickly. Let me thank you all. Let me urge our people who are involved here tonight to join ACS. Go to acslaw.org. Please get involved with our lawyer chapters. You see what a tremendous job Austin and these chapters did tonight. And also our Path to the Bench working groups that I mentioned. You can do this by emailing Peggy Lee, ACS Director of Chapters at capital P, capital L, I at acslaw.org. Please get engaged with our local and national discussions on court reform, which of course you just listened to. Please help educate your community about the importance of the court with op-eds, our Constitution in the Classroom program, and our general ACS programming. Also, please follow our work on Facebook, Twitter, Instagram, and LinkedIn. Again, thank you to the panelists and to the chapters. This is an exciting time and a very good time to have this conversation. Have a good evening. Thanks, everybody.